Chief Justice. Thank you. May it please the Court, Chief Justice, Justices, it's a privilege to be here on behalf of the New Jersey chapter of the American Academy of Matrimonial Lawyers. I will not belabor the point. My colleagues have spent plenty of time going through them. Certainly appreciate, Justice Albin, your comments, Justice Patterson, with regard to the obligation to the rights of counsel. Our position is exactly what has been discussed here today. There are many contracts that you do not have the right to counsel. This court has actually rendered decisions where you have talked about consequence of magnitude, for example, in the JEV case, where you did not obligate counsel. Those parties are able to waive their right to counsel. We talked about in our brief about access to justice, fairness in the application of law, and we have concerns about that provision in the statute. We also wanted to touch on, I know Robin talked about this as well, with regard to promissory estoppel and partial performance. What we're asking is really nothing new. We're asking that the way the court treated the situation in Maza and the situation in Klockner to be applied the same way to this class of people. And there's no basis to treat litigants advocating their palimony claim different than the wills and estate litigation case that had an oral contract, as well as the real estate case in Maza that had an oral contract. So we think by elevating the standard, the burden of proof, to clear and convincing evidence, so to avoid a manifest injustice, is the way and the path forward. I listened a lot to the Maker versus Ross oral argument, tried to prepare for Justice Albin's questions and Justice Patterson's questions, and Chief, your question as well, with regard to doesn't equity follow the law? And yes, that is a powerful and important long-standing maxim, but it's not without exception. That maxim does talk about exceptional circumstances when equity can come in and allow a remedy. And also the legislature did not unequivocally say that these long-standing defenses do not apply. So we are asking that the court confirm, just as they did in Klockner and as the court looked at in Maza, partial performance and promissory estoppel as defenses to also be utilized by this class of litigants, and notwithstanding the fact that the legislature did not have a clear prohibition in their 2010 amendment, that these defenses still would survive.
Do you agree we don't have to reach, if we were to determine that the enforced attorney provision is not constitutional, we wouldn't have to reach that issue?
We would not, and you gave us that out, your Justice, in the Maker versus Ross argument when we didn't have to reach the equitable claims if this court only dealt with the retroactivity. So technically, if you strike or otherwise deal with the mandatory obligation of counsel, you would not, and then perhaps we would be here a third time to deal with the equitable claims. But in case you were inclined to deal with those equitable defenses, we wanted to make sure that we made our position known to this court.
Thank you, Ms. Lawrence.